Thank you, Mr Deputy Chair. In rising to talk to this piece of legislation, I think that there is no doubt we all support absolutely the aim of toughening up the criminal code in respect to child sexual offences and the need to have stronger laws that will provide greater deterrence against those heinous, horrible and evil criminal acts that have damaged the lives of children and then generationally see them themselves living lives that can also end up damaging other people's lives. This is an issue that has become of plague proportions. There's a question, though, that remains unanswered in regard to the amendments that are before the House, and it's one as to why another amendment wasn't part of this legislation. I'd certainly appreciate the government providing an explanation as to why a recommendation that teachers who had sexual relationships with their students, that wasn't also an offence. And that was, as I understand, a matter that has been canvassed as where there have been real concerns about the abuse of that very important role, and that it's not enough. It is not enough simply to have disciplinary actions against people. There have to be far greater penalties to recognise that teachers who are entering into sexual relationships with students, some of whom may be over the age of consent, but using and abusing that position as a teacher in that situation is exposing children. And I think exposing them potentially to abuse. And I think that there is a question mark as to why that particular offence hasn't been adequately addressed in regard to these amendments that are before the House, given that, as I understand, this bill before the House was supposed to be about taking up some of the recommendations out of the Royal Commission in regard to child sexual offences. Why haven't these provisions been addressed? We really need to understand where did they go, how did they disappear from the legislation that we see before us? How do we know that the mechanisms that are in place are truly satisfactory to address what has been acknowledged in certainly recent cases as being an area potentially of great abuse, and one that we don't want to see any child groomed, be it by people they know or people who come into their lives through their network of relationships. But in regard to those who potentially have teachers, that small number, but still significant enough to have been acknowledged in recent cases, who have groomed and abused young people who have been in their care. In this case, they can be in their care when they're over the technical age of consent. So let's talk about this issue, but let's have an explanation as to why this as an additional mechanism wasn't included in this legislation before us. I know that there is a debate still to occur in regard to the LNP's proposal to toughen up against child sexual abuse, and that bill is still before the House and I understand will come forward for debate. And so it should. And I can't preempt debate, but I will say this. Labor's bill, in regard to what needs to occur, still doesn't go far enough. Children are so precious but so vulnerable, and they rely on adults to protect them. And tragically, as we know, some of those who are closest to them have abused that trust in a way that we find hard to imagine when that's not been our lives' experience. But I think we all know people who, as adults now, are able to tell their story, and it is devastating, the impact that it's had on their lives. And it may be decades later that they share those very personal and harrowing stories. And we don't want any child to suffer this evil, but we also don't want any perpetrator to have a loophole that allows them to avoid facing justice. We want them to know that the justice system and the criminal code that is there to underpin that is sufficient to provide greater protection for our most vulnerable. And that's why I raised that question before about why a certain aspect has been omitted from the Royal Commission's recommendations.
Thank you very much.